Voting Rights Act actually focuses on kind of like the big idea of not discriminating against somebody on the basis of race. And so it outlaws any type of discrimination that could be interpreted as disenfranchising Black votes. Now, what's coming up in these cases related to redistricting is whether or not you can functionally disenfranchise people, even if you're not explicitly taking an individual person's right to vote away. And there's a whole history of case law, some 40 years. It also relates to the 1982 kind of extension of the Voting Rights Act that talks about if you can tell whether or not minority votes, particularly African-American votes, actually count. And this relates to issues of redistricting. So could you draw district lines so that Black voters are always going to lose elections? They're never going to be able to elect candidates of their choice. I think what people saw in today's oral arguments, or what voting rights activists saw in today's arguments that gave them cause for concern, was the fact that Justice Kavanaugh seemed to express a skepticism about how long the Voting Rights Act still needed to be in place. And so people are wondering, as a result of his line of questioning, whether or not he would actually be open to saying, kind of like what was said in Shelby County versus Holder, that a remedy had expired, had lost its usefulness because America had turned a different leaf racially. For people who are in the voting rights community, this is a blockbuster case. And I think even if one doesn't consider themselves part of the voting rights community, this is actually going to be a pretty big case. And so the court's practice usually is to reserve the announcement of big decisions until the end of June. I think the question will be, is there enough time to redraw district lines and to have a qualification period that would actually allow you to be able to use those new district lines in upcoming elections in 2026. Now, Louisiana, unlike other states, does not have traditional primaries in the summer leading into an election season. They do sort of a big open primary on election day. And then if nobody gets a clear majority of the vote on in November, then they'll go to December runoffs. So that might actually give them more time to practically be able to digest the decision, make any necessary changes, and then have their qualifying season. But we, would have to kind of wait and see what the court does. But if it does upend the Voting Rights Act, then what that means is that it's going to be really hard for voting rights activists to make cases related to vote dilution. Making the claims that people purposely put all the Black people in one district, right, because they didn't want them spread across other districts where they could be influential, or the fact that you took a geographic concentration of minority voters and you split them up across so many districts that they were going to be a permanent minority in other districts. Like, that argument is going to be untenable in the absence of the current interpretation of Section 2 of the Voting Rights Act. Then there are the implications about sort of, well, what do states do? They may not have time to do anything in time for the 2026 election. But in particular, if state legislatures are controlled by people who would be favorable to where Louisiana currently stands on this issue in terms of the argument that they made before the Supreme Court today, then what you can see is likely Republican state legislatures redrawing district lines with an eye toward partisanship without thinking about kind of the racial balance, because they are no longer legally obligated to do so. So it makes those state legislative races all the more important, because that's going to determine who can draw district lines if you're going to do a mid-decade reapportionment.